So I've been informed that you started about the fiqh, Usul al-Fiqh, and the history and the model of writings, the Shafi'i way, Hanafi way, mixed mode, as well as the inductive, deductive, all these things we have you have touched in the previous classes. So today we are going to learn about the master architect of the Usul al-Fiqh, Sayyidina Imam Ash-Shafi'i. I hope everybody in this class must be very much familiar, heard at least, gone through some of his books and words, maybe in fiqh or usul al-fiqh, or maybe in Arabic literature or in the poem, Diwan al-Shafi'i, so many things. Prophet Sallallahu Alaihi Wasallam introduced an alimun Qurashiyun, or alimu Qurayshin, yamla'u tibaq al-ardi ilma. A Qurayshi scholar will be filling or enriching the horizons of the world with the knowledge, with
Recording stopped.
the sacred knowledge. So some of the interpretation says that it is refers to Imam Shafi'i. So Imam Shafi'i Abu Abdullah Muhammad bin Idris al-Shafi'i is a
Recording in progress.
one of the most prominent personality in fiqh as well as particularly in usul al-fiqh. So let's see what is the contribution of Imam Shafi'i in fiqh and usul al-fiqh. So giving a nod, fiqh, as we know, it is a human interpretation of the Islamic legal texts. For example, Quran and Sunnah, these are our textual evidence in Sharia. This is this hold, both of them hold the prominent in the ladder. Number one, Quran. Number two, Hadith. Then after that, we have a definite or finite textual evidences, and we have infinite cases, the humanity or the people or the Muslims who are facing in the world. So in order to find out the solutions, we need a human interpretation who are eligible and qualified to do this duty. Then the fuqaha came. The fuqaha interpreted the Quran and Sunnah. According to that, the humanity or the Muslim Ummah in particular are obliged to live and abide by. So fiqh is derived from the Quran and Sunnah, and it is for implementing the words and the instructions, prescriptions, or the commandments of Allah subhanahu wa ta'ala. However, the fiqh was there. In that meaning, fiqh was there from the period of Prophet Muhammad sallallahu alaihi wasallam, as well as in the period of the Sahaba and Tabi'in. Then, but it doesn't have a formal written format, a systematically or coherently written format for the fiqh. Then who did this job? This is done by Muhammad bin Idris al-Shafi'i Abu Abdullah. So he is the one who idealized, or he crystallized, or he coordinated, he embarked on the mission of giving a clear-cut instructions for doing the legal interpretation of the Islamic, the revelation, the Quran and Sunnah. Okay. However, we are not saying that until Imam Shafi'i it was a blank. No, there were efforts. But Imam Shafi'i stands out because of having a systematic way of writing, an organized form of writing, a complete form of writing, a coherent way of writing. That is the importance of a risala. So before Imam Shafi'i, for example, we are going to looking into the biography of Imam Shafi'i, how he started the career, how he started the life journey, where from he studied. So we will come across through the teachers. So his teachers also have written the books, but not as we see as a foundation for the later on works on the Islamic jurisprudence. So for example, Abu Yusuf is a very prominent, very pivotal disciple of Abu Hanifa, kulluhum ajma'in. He has written a book, Al-Kharaj, Kitab al-Kharaj, the book of taxation. That was by the, I mean, he was asked by the ruler then, Harun al-Rashid, to coordinate the law of land. So he has written. Muhammad bin Hassan al-Shaybani is also the disciple of Abu Hanifa. He has also written the book. So these books are there. Then why Risala or why Imam Shafi'i is being mentioned as a master architect is because of the coherent and complete way of writing of Usul al-Fiqh. I mean, recently some of the scholars, for example, if you search in the Google, or if you have the some time, you can look into the works of Wa'il Halak. He has challenged some of the arguments and the claims regarding whether Imam Shafi'i is the master architect or who was the some of the interesting discussions are there. You can refer to later. I mean, for those who wanted to have more information about the contribution of Imam Shafi'i. And also there are some other books regarding the works of our Usuli scholars, the founding fathers of the schools of Islamic law, namely Shafi'i, Malik, Abu Hanifa, Shafi'i, and Imam Ahmad bin Hanbal. Radiallahu anhum ajma'in. Okay, a brief introduction about Imam Shafi'i. He was born in 150 Hijrah. 150 Hijrah is the year in which Sayyidina Abu Hanifa was departed this world. His wafat was in 150, and Imam Shafi'i was born also in 150. So 150 is an important date to remember for those who are specializing the fiqh, Islamic jurisprudence. And he was born in Gaza, Palestine, and he studied, I mean, while he was too young, while he was 2 years old or very childhood period, his father passed away. So his mother wanted him to not lose the tradition or the lineage of the scholarship of his family. So she took him to the Makkah, and he was brought up in Palestine, in Makkah. In Makkah, he learned from Muslim ibn Khalid al-Zinji, Sufyan ibn Uyayna. One of them, the Muslim, was, if I'm not mistaken, was the Mufti of that period in Makkah. Then he went to Imam Malik ibn Anas, the founding father of Maliki Madhab, and he studied with him. And committing to memory Malik's collection of the hadiths and legal opinions of Muwatta. Muwatta is one of the very primary books. It's basically it is a collection of hadiths, but organized under the fiqhi chapters. So it is somehow the base of the madhab of Maliki, even though it is not as written as a fiqh book. It's a collection of hadiths, but it has to do a lot for the growth and development and the flourishment of the Maliki madhab. And he memorized, Imam Malik, Imam Shafi'i memorized by heart, committed to his mind the whole Muwatta while he was at 10 years old. While he was 7 years old, he memorized the Quran. Then he had some, in a difference of opinion with some of the works of Ahlul Hadith. I was listening to Dr. Saida Akma's talk. She was, at the end of the talk, was talking about Ahlul Hadith. So during that period, I mean, in the Tabi'un Sahaba period, and particularly during the Tabi'i period, the two schools of Islamic jurisprudence was, we can categorize as Ahlul Hadith and Ahlul Ra'i. Ahlul Hadith were more strict towards confining the legal interpretations as much as possible to the text, whereas the Ahlul Ra'i, because of the reasons are many. One, Ahlul Hadith was based in Medina. Ahlul Ra'i was located in Kufa. So Medina's access towards a number of extremely knowledgeable Sahaba group, so that they don't have a necessary circumstances to go out of the text, except in a few occasions. But Kufa is it's a kind of crossroads of several areas and the cultures. So they have a high exposure to the different cultures and the societies. So they had a number of unprecedented type of the cases. So they needed to have more work. For that, they used their reason, but not reason cut off from the Quran and Sunnah, but they were grooming over, breeding over the Quran and Sunnah to get, but to the extension to interpret the Quran and Sunnah. Maybe the Quran intended like this. They have a space of the options, opinion to work on the works of the Islamic legal interpretation. Then from Makkah to Medina, from Medina, he moved to Iraq. Iraq, as I mentioned, is a place where Abu Hanifa was settled and his disciples were there. So Ahlul Ra'i people mainly were there, the Ahlul Hadith in Medina. So after having spent a lot of time in the circle of Ahlul Medina, particularly listening to the works and the words of Imam Malik, when he came to the Iraq, he was seeing something different. I mean, the people there, they were more kind of criticizing some of the positions and some of the rulings given by Ahlul Hadith. So he was exposed to both schools. That helped him to understand the both sides. So he became a student of Muhammad bin Hassan and some other Iraqi scholars. Muhammad bin Hassan al-Shaybani, as I told, he is the student of Abu Hanifa. So he learned from Maliki, the founder of the Maliki madhab, and also one of the pivotal figures of the Abu Hanifa. Then he left sometime to Yemen, and due to some political reason, he has to come back, and he started teaching in Baghdad. Imam Shafi'i began one city to another city and made a deep impression on many of his students. For example, the another school is Hanbali madhab. The founder, Imam Ahmad bin Hanbal, was a student of Imam Shafi'i. So these four schools of Islamic law, for madhahib, is actually the founding fathers, the synergy between them, the give and take relationship between them is obvious by just having how these scholars have evolved and learned how the fiqh or how the Quran and Sunnah has to be interpreted. Then he moved to Egypt. So you see our tradition of our scholars is more about journeys, one place to another. So you will have a lot of exposure to different kinds of people, culture, scholars, situations. Maybe you are seeing something from your own area, but when you go and live with them, you try to understand what are the challenges, what are the situations, what are the problems they are going through. Then we will have a different kind of interpretation of the same scenario, which we have a different. So Imam Shafi'i's journey, he started from Palestine to Makkah, Makkah to Medina, Medina to Baghdad, Baghdad to Yemen, and coming back to Baghdad, then he moved to the historical city, the Egypt, the historical country, Egypt. Misr has a very important position in Islamic history, right? So he moved to there. Then he devoted all his time to teaching and dictating his works to his students. So he got a good students. That is why only four madhahib? There were another madhahib also. But one of the blessings Allah subhanahu wa ta'ala gave to these four, they got an excellent disciple, the students. The students' role in spreading and passing the knowledge, the disseminating the knowledge of the guru, the scholar, is undeniable. So Imam Shafi'i got excellent students. They worked together. They had a debates, they had a classes. The students were writing whatever opinions Imam Shafi'i was talking about. Then when he started his teaching and serious researches um, on fiqh and teaching, then he came across in time and again differences with his gurus. I mean, his teachers, Imam Malik, as well as the Hanafi scholars, particularly Muhammad bin Hassan al-Shaybani. And so he found something which were unacceptable from his point of view, that the way it worked. So, for example, in the next slide, for example, he was having a differences of opinion in some of the areas. He had a critical analysis of Imam Malik's works. So, for example, why Imam Malik rejected the sound hadith in favor of a statement made by one companion. There is a hadith and there is a qawl sahabi, but sometimes Imam Shafi'i feels that the qawl sahabi was given priority. Why? Definitely, it is not just because of favoring one Sahabi over the Hadith. He must have his own point of view. If you want to learn more about this, Imam Malik's positions and his work in the foundation of the Islamic jurisprudence, particularly, and also related to the fiqh and hadith, you can read a recently published book by Brill from Leiden, authored by Umar Farooq Abdullah, an American scholar. He has a book, very interesting book. I recommend you to read, Malik and Medina. Malik and Medina, very interesting book. Some of these views, not only these views, whatever has, I think it was his PhD, then he worked further and made it as a book. So this kind of the arguments, I mean, Imam Shafi'i felt that the sound hadith means Sahih hadith were not preferred, and the priority was given to words of companion. And sometimes the reasoning gave to the reasoning. If you learn more about Maliki Madhab gives interestingly important position for the Ashabu Ahlil Madina, a friend. Aqwalu Ahlil Madina, the Madina people's opinion, because Madina, where prophets lived a big amount of time while Islam was in the power. So they have a easy access, high exposure, a close contact, and intimate understanding of the Islamic legal text from the first and the foremost person in the interpretation, or in the Islamic legal, in the Islamic law, or in Islam at large. So that is why he thought that their words, their opinions got more a kind of soul to in terms of trying to understand and comprehend the meanings of hadith or Quran. So this kind of the view, I mean, the kind of claim of ijma, or preference for the words of tabi'un over sahaba, ijma' ahlil Madina, it became later on a big source of a proof for understanding the legal text. And maslaha mursala is one of the tools of Islamic legal interpretation, or the source of Islamic law. We have four major sources of Islamic law: Quran, Hadith, Ijma', Qiyas. But then there are certain other 6 or 7 another 7 sources which are not agreed upon by all scholars across the madhahib. Differences of opinion there. Some madhab accept istihsan, for example, personal equity. Some scholars give preference for the maslaha mursala. So maslaha mursala, from the view of Imam Shafi'i, the scholars of Maliki madhab, they were exceeding the boundary. They were going beyond the line. So one word about, or regarding all these words, Imam Shafi'i was giving a huge importance for the hadith. If hadith is genuine, then nothing else can supersede its importance when we try to understand or when we try to resolve any juristic issue. Then that is regarding the Maliki's views. Then when we come to Abu Hanifa radiallahu anhuma, he also found something problem. As we maybe in the previous class, when you learned about the inductive method and deductive method, the Shafi'i approach of was a deductive approach from the general to the specific, but the Hanafi was inductive from specific cases to a general theme. So from his point of view, that was not the proper approach. So all these things in mind, Imam Shafi'i came to forward to synergize, to systematically combine, to benefit from both of them, and to create and produce something more important, something important, and something which has a solid articulation of the way of interpretation of Quran and Sunnah. Or Quran, or the principle, we can say as a principles of Islamic jurisprudence. Islamic jurisprudence is the fiqh, and the principles are called as usul. So how can we create the views, the juristic views of Islam or Islamic jurisprudence? What are the methodology? What are the principles? What are the boundaries? What are the qawaid? What are the lawabit? All these things should be clearly mentioned, clearly written down. So he came forward for doing that job. So fiqh might become a practical application of this methodology. So based on this usul, the later on scholars can find the answer of any cases, any life problems when they need a divine light, divine guidance. Based upon these principles, they can move forward. So that is why Imam Shafi'i wrote Risala. So that is why his student Imam Ahmad bin Hanbal say, until Imam Shafi'i came along, we never thought of things like general and specific. General and specific refers to the am and khas. Am and khas, I don't know whether you have covered about it in any other lesson. Am means general, specific means khas. In Quran, when you try to learn the Quran and Sunnah, you can see some of the instructions or prescriptions or commandments or the is general. It has to be applied to everyone. But some are specific. Specific means which is only for particular situation. So that is why. So if we don't have this kind of understanding, maybe we will come across, we may stumble upon a lot of contradictions or misinterpretation of the Quran and Sunnah. So am and khas, this kind of the thing we were not exposed to before the work of Imam Shafi'i. That is a word by Imam Ahmad bin Hanbal. Am and khas, there is a mutlaq and muqayyad. Mutlaq is unconditional, muqayyad is conditional. So general is just like everyone. Specific is we are pointing out to something individual. Mutlaq is a kind of someone. Muqayyad is a particular person. So these are the certain terminologies and jargons which you might come across when you try to learn Islamic jurisprudence. So Imam Shafi'i, as validated by his contemporary scholars, he is the scholar more concerned about the qawaid, as we say, the deductive method. He brought the qawaid and the principles, general principles, so that if you have a clear-cut idea or a strong and consolidated understanding about them, then it would be easy for you to deal with any minor issues and details. So far there is a kind of even though a little differences of opinion there, are they there is a close to a unanimous opinion that Imam Shafi'i is the master architect or the first one to author a coherent, systematic, organized, complete in a way book on Islamic jurisprudence, Usul al-Fiqh, principles of Islamic jurisprudence. Imam Shafi'i got another books also. For example, in the Fiqh, he has written Al is the Imam Shafi'i's book in Fiqh. Al-Risala is the work in Usul al-Fiqh. So I think it is meant to show the journey of Imam Shafi'i in the quest of acquiring the knowledge from Gaza to Makkah to Medina. Then he moved to Yemen. Then he continued his journey to Iraq. Then he has came to Al-Misr, and his qabr is in Misr, in Egypt. So, and also when we learn about Imam Shafi'i, we can also come across Qawl Jadid, Qawl Qadim. So Imam Shafi'i, some of his opinions while he was in Iraq was revisited and reconsidered, and he reformulated some of his views while he came to the Misr. So Iraq is his Qadim period, the old period. So the views there from there were called as a Qawl Qadim, and when he came to Misr, the Qawl were called as Qawl Jadid. Now we got a brief idea about Imam Shafi'i. Now, what is the work of a Risala? Risala is as I repeatedly mentioned, is a logically systematic method of legal reason. That is the work of the Risala. Even though Risala is not a complete work, but it has become a room of the foundations. It has become the foundation of the Islamic law. Then it became a model. It became a benchmark. It became a yardstick to go further regarding the education, or regarding the learning, or regarding the writing, or using the fiqh, or understanding the legal text. Well, the Risala, the word meaning is a kind of message. Risala is a letter. When you write a letter, why this is written? It's been said that his contemporary, another scholar, Abdurrahman ibn al-Mahdi, who wrote to Imam Shafi'i to write on the methods, or the sound, proper way of interpretation, where the Sunnah has to be used. What is the role of Sunnah in Islamic legal interpretation, or in Islamic jurisprudence? This kind of the questions, because at that time, after the period of the Prophet ﷺ, there is no a written formula of creating the Islamic jurisprudence. So some people were going in crossing the line, or doing without the proper understanding. So there was a need. So Abdurrahman al-Mahdi, he asked to write a book on it. So he returned. So his letter is actually a letter, became a risala. So it's been said that Imam Shafi'i wrote two risala. That is Risala Qadim and Jadid. But the Qadim is not yet to us. It was, it failed to reach to us. But the new Risala was the superior, because he's after the revisiting some of his views, he wrote again. That Risala is available now. You can find it in online, and there's a book. There is an edited volume. So some of the contemporary scholars came and they gave the readings and the meanings, or what is the, annotated works are available. Now, Risala, the content of Risala, there is a general topics on Islamic jurisprudence, and he brings detailed examples. Then what is the role of Quran, what is the role of Sunnah, then a brief discussion about the consensus and analogy. Consensus is ijma', the ijma' of the ulama, al-mujtahidun, ijma' al-mujtahidun. I mean, if something happened, all mujtahid on the earth, across the globe, have a single opinion on that, then that is called ijma', consensus. That cannot be breached at any time. It has become a very strong source of Islamic law. Analogy, as we have two cases, so we are comparing a case which doesn't have any ruling or explicit ruling from Quran and Sunnah, but there is another one which has an explicit ruling from the Quran and Sunnah. So what doesn't have, it will be compared with what came with the proof. If the illah, if the reason, the racial is the same, then the new case will be also given the same ruling of what has already a proof from the Quran and Sunnah. Then he learned about istihsan. Istihsan is juristic preference. Usually it is translated as a juristic preference. That means that it is coming out, exiting from a general ruling and resorting to a new ruling on a particular situation. For example, in Islamic jurisprudence, we can say you cannot sell something which is not in your possession. That is the general ruling. You cannot sell a car which you are going to possess in 2025 now. Why? Because it is not in your possession. Then there is a specific ruling on salam. Salam is, for example, somebody selling his fruits, which is going to ripe or going to emerge on his trees later on, but he can do for helping each other. I mean, the farmer needs the money now. So one specific case comes out of the general ruling. So that is istihsan. Imam Shafi has a very strict criticism against this. So he has written about this also in a risala. We have 8 more minutes, inshallah. Then he talks about Ahlul Kitab and Mushrikun and Kafirun. Ahlul Kitab means the Christianity and the Judaism. Actually, the people of book. I mean, they have Injil, they have Torah, but later on it was inserted with a falsehood. Mushrikun means the idolatries. They work idols. Then it was the mankind situation there. Then because of the state of misbelief or disbelief or the kufran or the kufr, Allah subhanahu wa ta'ala decided to send for the Prophet Muhammad sallallahu alaihi wasallam in the beginning. Then he talks about in Quran, what is the status of Quran? The Quran comes the number 1. It's a basis of the legal knowledge. The Sunnah can be called as a bayan or tafsir or sharh of what came in Quran. The Quranic legal province, you can see the chapter as a bayan, al-bayan declaration, the comprehensive legal statements of the permissions and prohibition, the rewards and the punishments, all comes under al-bayan. Now there are 5 categories of al-bayan, specific legal provisions which allow no other interpretation. I mean, Quran itself is enough. I mean, Quran's statement on this is gives no room for the doubt. Just like the Shahada, the Salah, Zakah, the fasting, and the Hajj. These are some of the duties which because no other explanation. But legal provisions, whose modes of observation is specified by Sunnah. I mean, the Quran, Aqimus Salah is there, but how many rak'ah, which prayer got this? I mean, the specific intrinsic informations and the details of the prayer we learn from a Sunnah. So Sunnah became explanation, tafsir, or the shara of what came in Quran. Broad legal provision which the Prophet particularized. Then there are things Prophet Sallallahu Alaihi Wasallam explained. I mean, some of the things which Quran is silent about it. We don't see an explicit or obvious ruling on that. It is somehow silent about that case, Quran. So Prophet Sallallahu Alaihi Wasallam will be giving an instructions on that kind of bayan. The broad legal provision laid down by the Prophet Sallallahu Alaihi Wasallam in the absence of the specific Quranic text. That is what I said now. Then rules which are sought by the exercise of ijtihad or by the means of al-qiyas. As in the beginning of the class, I mentioned the Ahlul Hadith, Ahlul Ra'i were, they have, due to the geographical reasons, due to the other reasons, I mean, they were forced to do the exercise of ijtihad, their personal reasoning, but not cut out or cut off from completely from the Quran and Sunnah, but based on Quran and Sunnah. I mean, ijtihad is a very broad topic to learn because mujtahid, who are mujtahid? What are the qualifications of ijtihad? And when somebody can do it, ijtihad got different categories. Ijtihad mutlaq is there, ijtihad muqayyad is there, ijtihad juz'i is there. So it's those who are eligible to do that, their ijtihad is become also source of Islamic law for us. Then, as I mentioned, al-am wal-khas is also was explained by Imam Shafi'i. I mean, what is the meaning of am? General rules, which mean meaning may be clarified by the context. General rules, only the wording of which indicates the implicit meaning. General rules which only the Sunnah can specify as a general or particular, it can be also an extension of what we talked about al-bayan. So in Quran, we cannot, that is why the scholars have said, you cannot be just, you know the Arabic language, you can do interpretation. No. Why? This kind of particular things are there. There is a nasakh, abrogated things are there. There is a am, there is khas. So if you don't know the context, the reason, the wisdom, and which is am, which is khas, which is nasikh, which is mansukh, it become an easy way to make mistakes in the interpretation of Quran and Sunnah. Then talks about the Sunnah. The Sunnah, that is one of the huge contribution of Imam Shafi'i to the Islamic jurisprudence. He talked about Sunnah and tradition, and what is the role of Sunnah in the field of Islamic legal legislation. Imam Shafi'i has talked in detail and broadly about this aspect also. Then what is, when a hadith become, tradition means hadith, prophetic tradition. Authentic hadith, unauthentic hadith. If there are two authentic hadiths which comes in contradiction, then what should be done? What is the ta'wil, or what is the tawfiq? What is the jam' between two hadiths? It may look like contradictory in an exterior way, or in a general understanding, it may look like a contradicting, but there is a way of the wheel for that harmonization between these two hadiths. Imam Shafi'i talks about it. Because of giving this interpretation, what is one of the benefits is that otherwise some of the authentic hadiths will be rejected. But when he talked about this kind of the ta'wil, both hadith have had its own space there. Then al-ijma' wal-qiyas. Both I mentioned, ijma' is the consensus, al-qiyas is the analogy. Then istihsan and ikhtilaf. Istihsan and ikhtilaf, the difference between them, istihsan, as I say, from the general to the specific, because of that particular jurisdiction in that situation, coming out from that ruling to a specific ruling will be good. There is a benefit, there is a maslahah. And Imam Shafi'i also talked about ikhtilaf. Ikhtilaf means the differences of opinion. There is a prohibited way of ikhtilaf, disagreement. There is a permitted one. So the permitted, the disagreement is only on there is a chance of ijtihad. If there is a nas, no ikhtilaf is accepted. This is an example of how can we harmonize. Prophet Sallallahu Alaihi Wasallam say only the good people need to be imam. In another one, Prophet Sallallahu Alaihi Wasallam, just and unjust men, both of them can be the imam. Then is it contradictory? One say only good people, another one only both can be. So what is the harmonization? Then the scholars mention that one refers to the imam in the masjid in the Qabila got a masjid, then the good people lead the prayer. The other one relate to it gives implication towards the leadership. There should be a leadership. You shouldn't challenge the leadership, because the moment you challenge the leadership without having a strong justification, it will lead to so many other chaos and turmoil, disorder in the society. Finally, let me close with a few words. Abrogation also is a part of, it has been also mentioned in a risala. Abrogation means, firstly, Quran say, okay, if somebody is going to die, he can do the wasiyah for his parents and the nearest of the kin. Then that ruling was abrogated because of passing of the maslaha of that ruling for a particular period. It has gone. Then the Quran or Hadith brings about a new ruling, abrogating the previous one and coming to la wasiyat lil warith. Father and the parents, they are going to be the inheritors. They have the right of inheritance. So you cannot make a wasiyah for them. Then Quran came, abrogating the previous verse. That is all. So hopefully you got somehow an idea about what is the contributions of Imam Shafi'i, particularly also with special reference to Al-Risala. Wa jazakumullahu khairan. Barakallahu fiik. Assalamu alaikum.